Welcome again to Impact of Arrest and Conviction Records, sponsored by the ABA Commission on Domestic and Sexual Violence. Today's webinar will be facilitated by Kate Mogulescu, lead attorney for the Survivor Reentry Project, and Jessica Emerson from the Human Trafficking Prevention Project at the University of Baltimore School of Law.
Hi, everyone. This is Kate Mogulescu, the director of the Criminal Defense and Advocacy Clinic at Brooklyn Law School and the lead attorney on the Survivor Reentry Project. Together with Jessica Emerson, we will be leading today's webinar, and we look forward to exploring with you the following issues. First, we're going to give an overview of what the scope of mass incarceration is in the United States, tearing apart what is commonly referred to as mass incarceration into separate categories and understanding sort of what the breadth and reach of the criminal legal system in the U.S. is, how many people are detained, imprisoned, jailed, but more than that, what are the consequences that flow from even just an arrest without detention or incarceration. We're going to define what constitutes a criminal record, how that information is stored, accessed, and used. We'll look through at the collateral consequences that flow from arrests, how people who have been involved in the criminal legal system suffer from specific consequences and how that impacts their ability to move forward. We'll try to, although I'm not promising that we're going to be incredibly successful at this part, understand why it is that the criminal legal system functions the way that it does. Some of these are questions that we simply cannot answer, but in breaking down the legal system's functioning, we can get a more deeper understanding of what the people that we are all working with, and I'm looking at who's attending this webinar, might be experiencing and how we can further advocate for and assist them. And then finally, we're going to think specifically about reentry and collateral consequences for survivors of human trafficking. And we'll survey what exact needs attorneys need to be looking for or considering when we provide legal representation. And we will give hopefully the foundation that will contribute to participants' ability to attend the next several webinars in the series, which we will identify at the end of our webinar today. To start off, we'd love to know who we are speaking with. For anyone who's ever given a webinar, you understand how completely awkward it is to simply be talking into your telephone without seeing anyone's faces or having the ability to sort of engage with body language or understand. So we wanted to at least know who you are. For that, we're going to ask you to participate in a poll where you tell us exactly what your role is. And we'd hope that you will be able to select the category that best identifies you, whether you are a public defender, another criminal defense attorney, a civil legal services attorney, pro bono attorney, a social worker, a prosecutor, a judge, or another member of law enforcement. Once again, if you can just indicate which best describes your role: public defender, another type of criminal defense attorney, a civil legal services attorney, pro bono attorney, a social worker or other advocate like case manager, a prosecutor, judge, or another member of law enforcement.
We need a little background music here, Kate.
I thought you were singing.
Do, 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 do. That's the best I can do.
All right. Well, it looks like we have a good range of roles joining us here today and different perspectives. So thank you for participating in that poll.
Okay, so this is Jessica Emerson. Good afternoon, everyone. Thank you so much for joining us on our webinar today. We are going to take a look, like Kate said, at the scope of mass incarceration. We are going to start broad and talk about what mass incarceration looks like across the country, but we're then going to drill down a little bit and see the ways in which mass incarceration disproportionately impacts certain marginalized groups. I want to apologize in advance. I have a little bit of a cold. I made sure to medicine up before we started, but if I sound a little hoarse or hop off for a coughing fit, I just wanted to let you know what was going on. Okay, so let's start broad. Mass incarceration by the numbers. What are we looking at when we are thinking about what mass incarceration is and what it looks like in our country? So in the United States, over 2.2 million people are currently confined in state and federal facilities. So incarceration on both the state and the federal level, that works out to approximately 700 per 100,000 people. However, if we include people that are on parole or probation, so those who are not confined in these facilities, we are talking about 1 in every 37 adults in the country being under some form of correctional control in 2016. And yes, this number has shot up significantly, as you can see, 500% in the last 40 years, but we're going to break that down a little bit. And just for kind of a visual aid to understand that 500% in the last 40 years, this map is by the Sentencing Project, talking about prison populations. And as you can see, down in 1925, it was at a very low level, started shooting up in the 70s, and peaked in about 2010, and has started to steadily tick down. So we're talking about a major wave of incarceration beginning in the late 70s, early 80s. I'm sure, as some of you might assume, this is linked, or this has been linked to the war on drugs. Sentencing policies that emerged from the nation's war on drugs, which did begin in the early 90s, caused incarceration rates, prison sentences, and the like to skyrocket, and has directly led to the numbers that we see in terms of mass incarceration right now. For example, there was a law enacted in 1994, the Violent Crime Control and Law Enforcement Act, that established a 3-strike mandatory life sentence for individuals who were repeat felony drug offenders. Just to kind of put it in proportion in terms of the federal prisons, half of the people who are serving time in federal prisons are there for drug offenses. And that type of concentration is no different on the state level. The number of people serving time for drug offenses in state prisons is 10 times higher than it was in 1980. So that is kind of the national scope that we are seeing, an incredibly large increase in the number of individuals who are incarcerated generally. But for anyone who has ever heard me speak about this type of stuff, we know that there is no one issue. So let's drill down and think about how different marginalized groups are impacted by the criminal legal system. One of the groups that is disproportionately impacted by incarceration and prison policies and policing are people of color. Black men have the highest rates of incarceration across all age groups. They are 6 times more likely to be incarcerated than white males, and 2.5% more likely to be incarcerated than Hispanic males. And the Sentencing Project came up with a really chilling statistic, which is basically that 1 in 3 black men born in the year 2001 can expect to go to prison in their lifetime. There is not enough time to talk about the intersections, or in depth anyways, the intersections with poverty and policing practices in communities of color and low-income communities. But the intersections are multiple, and they are continuing to this day. If we continue to consider the disproportionate impact on people of color, the issue of jail time is actually different from when you're comparing people of color and white folks. Black and Hispanic offenders are more likely to be sentenced to jail time than white offenders. and they often are given longer sentence than white offenders who are convicted of the same or similar crimes. And I gave you an example there that African Americans and Latinos constitute 57% of people in state prisons for drug offenses, despite the fact that usage rates are similar among ethnic groups. And if anything, we're seeing usage rates higher among white people than people of color. The intersection of race and poverty can also be seen when we're talking about mass incarceration. Poor black defendants receive sentences that are approximately 13% longer than other defendants. Okay. The other group that we see disproportionately impacted by incarceration practices are women. The rate of incarceration for women has increased by more than 700% in the period of time between 1980 and 2014, and we have outpaced men by more than 50%. The types of offenses that we are convicted of tend to be more on the nonviolent side. You'll see I saw 61% nonviolent offenses versus 37%. And we are talking about a group of people that have, the majority of whom have children under the age of 18. So there are a whole host of challenges with regard to raising a family that we will get to a little bit later on in the program. There is an intersection between women and race as well. So in the year 2014, the imprisonment rate for African American women was more than 2 times the rate of white women, and Hispanic women were incarcerated at 1.2 times the rate of white women. So again, this issue does not affect all Americans the same. There are challenges that are unique to the intersections of race, of class, of gender. And we're going to take a look at yet another intersection in our next slide. LGBTQ people are also disproportionately impacted by prison and policing policies. Generally speaking, we have less data on LGBTQ folks in the prison population than we do on the preceding groups. But if you think about why this group might have more interactions with police, they are more likely to be victims of discrimination, stigma, and crime. They are more likely to be homeless, more likely to be working in the underground economy, which carries significant risks of incarceration. And they are also very likely to be victims of profiling and discriminatory policing. We're pretty engaged with our transgender female population here in Baltimore City, and it is incredibly common for police officers to stop and assume that our clients are engaging in some form of sex work merely because they are walking down the street. So they are more likely to be the victims of profiling and policing that result in them being locked up. But once they get into custody, LGBTQ folks are more likely to experience harassment and abuse in confinement facilities. Generally speaking, across the United States, transgender people in particular are housed by the sex that they were assigned at birth rather than by their gender identity, and their gender identity being the person's internal sense of whether they are male or female. So typically, for instance, if a transgender female is incarcerated, she will most likely be housed with men because she was assigned male at birth. And I'm sure it probably comes as no surprise that that makes trans people much more vulnerable to physical violence and sexual assault. In fact, there was a study done out in California's prison system, that found a 13% higher rate of sexual assault among trans incarcerated persons than non-trans incarcerated persons. The other thing that is important to note is that U.S. prisons can also block access to transition-related health care, such as hormone therapy, to incarcerated trans people, even if that type of therapy is prescribed by a doctor. So once these folks are incarcerated, there is harassment, there is abuse, and there is commonly segregation to, quote-unquote, protect the individual from that increased rate of violence. But segregation carries its own risk of significant challenges and problems. Also, generally speaking, LGBTQ folks are more likely to have their sexual orientation and gender identity used against them in legal proceedings. So all of the stereotypes and the profiling that we know happens to these individuals, this is commonly something that they experience when they are in the middle of legal proceedings. And at this point, I'm going to turn the next section over to Kate.
Thanks, Jess. So in pulling out a little bit and broadening our scope, Jess just gave some pretty stark statistics and examples of the rate of detention and incarceration across the country, and that is staggering. And when people say mass incarceration, oftentimes they are talking about the number of people detained or imprisoned or jailed in this country. But there is a sort of more subtle and even wider spread issue contemporaneously happening, which is just the overall reach of the arrest and criminal legal system separate and apart from detention. The criminal legal system, right, and the impact of a mere arrest, even if an arrest does not lead to detention, incarceration, or prison, there's still huge impact to that interaction on individuals and communities. So when we talk, for example, about criminal records and what is a criminal record and how do criminal records impact people, we use sort of even terms of art, and we're pretty amorphous in our phrasing. But really what we're saying here is the record of every time a person touches the criminal legal system by virtue of their own arrest, and where there is a risk of incarceration. But many times that person isn't even detained or incarcerated, but really what the sort of web of complicated legal proceedings and consequences that brings that person into, that's what we'd like to explore a little bit more. So criminal records are, the term itself is used in different ways, but what we mean to say for purposes of our webinar today is this is a record of every time a person has touched the criminal legal system and what information then people can access about that person or that arrest or that interaction moving forward. The interesting part for me as someone who has practiced in the criminal legal system for many years is how this becomes the single most defining characteristic of someone once they are criminal legal system involved. It is sort of the baseline by which people are judged, sorted, evaluated, labeled, and dealt with. And it's all based on their record of prior contacts. Even more than that, what has been so important to learn is that most people walking around have had criminal legal system involvement, but actually have no idea what record then follows them into the future. Most people don't know what information potential employers can access or what information even the police have should they be arrested again. So there's a lot of uncertainty and confusion about what actually appears on criminal records, particularly for those marginalized groups that Jess just went through, particularly for people who might not have the same level of resources or access to information. So a criminal record really refers to, as I said, the record of every time a person has touched the criminal legal system. It's what information follows them. And a lot is dependent on state and local practice here and where that interaction occurs, but really it can break down into roughly two categories. A history of times that someone has been convicted of or found guilty of a crime, or a report of that person touching the criminal legal system in the form of an arrest. In some states, like New York, when you are arrested, but your case is not prosecuted any further, or you have a successful outcome of your case, the case is dismissed, the case you go to trial and you prevail and you are acquitted of the charges. New York law requires then that every reference to that arrest incident be removed from your fingerprint history. Therefore, in the future, should you be arrested again, that case, that arrest, that prosecution will not appear on your record. I have learned that New York is actually in the minority here on this one, and New York offers more protections to people who successfully resolve their criminal cases than many other states, and actually most other states in the nation. In most states, even if you prevail in court and you are able to get a charge dismissed or secure some sort of disposition that avoids you being found guilty or being convicted of a crime, the record of the arrest itself still follows you and is still connected to your fingerprints in a way that is publicly disclosed moving forward. What can a criminal record contain? A criminal record, which is a report of all your prior contacts with the criminal legal system and every point at which you have been fingerprinted in connection with an arrest. The report itself contains basic identifying information. The report can contain a history of addresses that you've provided to the police that when you've been arrested, or can consolidate information from other sources and pull other addresses that you may have used or registered in the past. The criminal record also for each of those incidences will describe the offenses charged, sometimes, as I just explained, regardless of the outcome of the case. A criminal record has basic physical descriptions, including any distinguishing marks: your height, your weight, your tattoos, hair color, eye color, perceived race, perceived gender. The criminal record also usually will list times that you have failed to appear in court in the past, or what we call bench warrants, times when you were directed to appear in court and did not. And some criminal records go even further and include information like tax liens or bankruptcies. It really depends on the location where the criminal record is generated and who is originating the report. It's also important to consider, and I started to touch on this a little bit, the distinction between an arrest and the outcome of a criminal case. When you are arrested, right, in order for a case to commence in a court, a prosecutor actually takes that arrest information and converts it into a prosecution and charging you with a crime. There are many instances where people are arrested, placed into custody by police, taken temporarily into custody, let go, and then prosecutors opt not to bring any charges against that person. That can happen before a person even sets foot in a court, where there's an arrest, they're taken temporarily into custody, but then no court proceeding follows from that. Once a court proceeding has commenced, the outcome of the case is dependent on several factors, but include then the participation of the prosecutor and the oversight of the judge. So some people's arrest records don't indicate any court information because that person never even made it to the part of the process where they entered a court. Once someone enters a court and is facing criminal prosecution, there's quite obviously a prosecutor involved, and there's different outcomes then that can flow from that criminal prosecution. The person can be convicted or found guilty of all of the charges that they face. This can happen by virtue of a trial, or much more commonly by virtue of a guilty plea. The percentage of criminal cases that are resolved with guilty pleas in this country is absolutely astounding. Of course, I'm not prepared enough to actually have that percentage for you today. And for those of you that are listening that know me, you should be not at all surprised. But the last that I checked, it was well over 95% of criminal cases are resolved by virtue of a guilty plea. But you can also be convicted or found guilty at a trial, and a trial can occur either in front of a judge or with a jury. You can be acquitted of a charge or found not guilty. A charge can be dismissed for a lot of other reasons before you even get to the trial stage. A charge can be dismissed because a judge or a court finds that there's a lack of evidence sufficient to move forward. A charge can be dismissed because there are speedy trial restrictions or certain time periods by which a prosecutor must bring a case and be ready for trial. And if the case exceeds those specified time periods, the charge must be dismissed. Charges can be null prossed, or another instance where a prosecutor, within their discretion, decides not to prosecute a case. Charges can be resolved with what's called a deferred adjudication, where a case is basically held in abeyance while someone completes while either the passage of time elapses or someone completes some sort of supervision or probation sentence or a program or some other condition that completes their adjudication. And finally, through the process of plea bargaining, many times what happens is criminal charges are resolved with a guilty plea to a lesser charge. This is sort of the let's make a deal approach to the criminal legal system. For any of you who have spent time in criminal court and observed proceedings, you see this actually happening, where the DA is willing to drop to this, the defense is willing to accept this, there's some bargaining that goes back and forth, and ultimately there's some sort of compromise or settlement that results in a plea to a lesser charge. Whether or not each of these outcomes actually make their way onto someone's criminal record in perpetuity is a very complicated question, and a lot depends on what kind of records we're talking about and where they're maintained. So each state has its own way of tracking and maintaining criminal record information. Similarly, the federal government gathers, and each state reports information to the federal government on local and state level arrests. The federal government obviously also tracks its own arrests and prosecutions. And then what has sprung up over the last, I don't know, I would say decade, but I'm guessing at that completely, are a bunch of public databases that are completely unregulated, that are run either by private companies, most of the time by private companies, that the public have access to, that are either free searches or cost-based searches that pull information from a variety of sites. What's important to say about the unregulated public databases is that their information is notoriously inaccurate, yet people rely on them. They sort of, as I said, pull information, do not verify or confirm the outcome information about cases. They conflate often different individuals with similar names, similar dates of birth. The only way to get a complete and accurate criminal record history of someone is via fingerprinting. Often, if you run a search through one of these unregulated public databases, or if you're in a state that allows you to search their records just based on name and date of birth, or name and some other identifier, you will not get an accurate and complete result. This is for a lot of reasons. One, many people give conflicting information when they're arrested, hoping that to lessen the consequences or risk of that arrest to them. Second, the police, in effectuating an arrest, are not the best record keepers. They're not the best spellers. This is nothing to disparage police officers generally. They're not the best at writing down or even listening to how people identify or what names people, how people spell their names. So this leads to records that are just in a variety of names, dates of birth. They're simply typographical errors. So when you do a search that's just based on a name or date of birth, the odds of inaccuracy are very high. Different entities can access criminal record information at different points. And again, this is an area where, depending on what state you are in and what their policy is about arrest records or conviction information, this may vary. So as I've already explained, the public can access criminal record information, one, through these unregulated databases, but also increasingly, courts and court systems are putting information online. In some places, this is just active pending case information. So in New York, for example, you can't do a criminal history search of someone online, but you can do a name-based search to see if someone has a pending criminal matter. Other states have a wider level or a higher level of records available online. For example, in the Miami-Dade system in Florida, you can actually search through the court website criminal histories, and you can pull up, in many instances, case documents with very specific information about the people charged, what the offenses charged were, and outcome of the case. Of course, the criminal legal system can also access criminal record information. So every time that someone is arrested and fingerprinted, a criminal history record is generated, and that is what accompanies them in their journey through the criminal legal system. In New York, for example, that criminal history record is generated at arraignment, at their first court appearance, and it becomes the foundation, the basis on which, for example, their liberty is determined, whether or not they're released, if they're released with, whether it's with bail or any specific conditions, or whether they're detained. Similarly, their criminal history record determines what kind of plea bargaining they can expect. Many places across the country, many criminal legal systems treat the adjudication process in criminal court like a algorithm, a formula, a rubric, where based on someone's number of prior contacts in the criminal legal system, based on the level or severity of their current charge, and based on, quite frankly, any other arbitrary factor, what the DA or judge or defender ate for breakfast, anything, right? You multiply these factors, you analyze them, and you come up with what the appropriate disposition is. This is actually different from what we're taught in law school and what we see on Law and Order and what our general view of the criminal legal system is, because we're taught to believe that cases are resolved in criminal court based on an exploration of the underlying facts, an investigation, witness testimony, a probing of probable cause, reasonable cause, guilt beyond a reasonable doubt. But as a matter of fact, most criminal cases in most places across the country, for efficiency's sake, are simply resolved using some formula that's designed to simultaneously expedite the resolution of cases while sort of serving the other larger goals of the criminal legal system. Landlords, potential employers can also access criminal record information. A lot of this depends on what systems they use, how much they're willing to invest in the accuracy of the records they're seeking. As you can imagine, when landlords or employers use some of these flawed databases to vet people, whether for housing or for jobs, they can rely on information that's inaccurate, and that can cause, obviously, problems for people. And one other important consideration is that immigration officials can access criminal history information at a very high level. That is, regardless of what information is stored in public systems, regardless of what New York State, for example, does with sealed cases or cases that should not appear on someone's criminal history. When people do biometrics for immigration cases through USCIS, USCIS can access all arrest information, regardless of what the outcome of the case was.
Okay, I remembered to take myself off mute. All right, so we started off with kind of the bird's eye view of how big a system mass incarceration is in the United States. And then Kate helped us drill down even more to highlight that in addition to all the people, the 2.2 million people who are incarcerated, we also have people who are not incarcerated but whose criminal records follow them wherever they go. And this is going to be the bigger focus of our discussion today, or my talking at you today, I should say.
Jess, can I just, there are two questions that have come up that I think are important. If I can just answer those quickly before we move to the next section. One question involves if fingerprinting is not taken at the time of arrest or citation, then are there any other ways to ascertain someone's real criminal history record other than a name search, for example, or other than the more limited means that I described? And the answer is yes, if you're working with someone who does not know their criminal history, or that's not part of the documents you've been provided as part of your case. There are both state level and national ways to do fingerprinting that would generate a fingerprint-based criminal history record. And that's information that we can actually provide to all the participants about the national search and the national results, but each state's process and procedure is a little bit different. Almost all states at this point are contracting with private companies, to do the fingerprinting that accesses the state criminal history database. A second question that's come up from the audience is if we would consider the services offered by Lexis or other similar searches to be flawed because they're not based on fingerprints. And Jess, you'll let me know if you disagree, but my feeling here is that any search that is not based on fingerprints is not 100% complete and accurate. And there may be some parts of the information that could be derived from a Lexis search or even a name-based search through another search mechanism that will be helpful, but a complete history cannot exist separate from fingerprinting.
I agree. Excellent. Okay. So let's transition to talking a little bit about the term collateral consequences. What collateral consequences flow from arrests and convictions. Because like Kate highlighted, you don't have to have been incarcerated, you don't have to have been convicted of anything to have a criminal record attach itself to you. So Kate gave you how things are handled in New York. In Maryland, for instance, we have Maryland Judiciary Case Search, which is an online public database that contains every single record of any person's contact within the state of Maryland with the criminal legal system, with the civil legal system, and with traffic cops, with the transportation system. And every single thing is visible on Case Search and will never, ever, ever come off unless someone does something proactive to get it off their record. So I could have been arrested 50 times and never been convicted. Every single bit of that, including what I'm charged with, where I lived, obviously the accuracy is a concern, but I will have a criminal record for the rest of my life unless I do something proactive or I use some form of legal relief that's available in Maryland to get rid of that. So we are talking about way more people than the individuals who are currently incarcerated. So let's give some general definitions so we are all on the same page. Collateral consequences simply means the penalties or disqualifications that are attached to an arrest or to a criminal conviction. Now, these collateral consequences can be automatic, so collateral sanctions, which is a legal penalty imposed automatically on a person at the time of a conviction, and that would be having to give up a firearm, having to register as a sex offender, but some collateral consequence that is triggered automatically at the time of conviction. What is far more common is the third bullet point, which are discretionary disqualifications. These are legal penalties that are authorized to be imposed but not required. And that is where the majority of the clients that we deal with have challenges. So let's explore that a little bit. So I typically start with housing when I'm talking about the challenges for individuals with criminal records, because housing is really the linchpin in terms of preventing recidivism, promoting safety and stability. When people don't have a stable place to live, all of the other things that we try to do, get housing, get health care, make appointments, all of those things are compromised or can be compromised when we are unstably housed. So I like to talk about housing first. As a general kind of a general backdrop to our discussion, the federal government sets housing policy, and then local housing authorities then interpret that based on the specific issues within their jurisdiction. There are challenges, or having a criminal record brings challenges with retaining housing as well as obtaining housing, but we'll go through retaining housing first. Many of you may be familiar with the one-strike eviction policy. This was, again, created in the shadow of the war on drugs, created by the Anti-Drug Abuse Act of 1988. It was strengthened in 1996 by an executive order signed by President Clinton. And what the one-strike eviction policy says is that tenants may be evicted from public housing for the criminal activity of a household member, a guest, or a person that is simply considered to be under the tenant's control. And this particular criminal activity, and notice I'm not saying conviction, I'm saying criminal activity, that occurs on the premises or off the premises, regardless of whether or not that public housing tenant was aware that the activity was taking place or if the activity resulted in a conviction. And so this was the language that was created in 1988, but when it was determined that a lot of local housing authorities were not, they weren't using this regularly in their work, the executive order actually linked abiding by this particular one-strike eviction policy to federal funding. So the language came from the Anti-Drug Abuse Act. It was mandated, so to speak, by the 1996 executive order. I would hope that as you're kind of reading through this, you're going, wait, so even if this person doesn't live with me, even if this person does this criminal activity outside of the apartment where I am living, or even if I'm aware that this criminal activity has taken place, it feels a little unfair that I would be held responsible and could indeed be evicted for something like that. And while I agree, this analysis was upheld by the Supreme Court in 2002 in the Department of Housing and Urban Development versus Rucker. And the key piece, there were a number of individuals who were tied to this lawsuit, but the one that I always remember is an individual who had their care coordinator, so someone who was helping them with their day-to-day care, and this person had cocaine on them. And the elderly person was actually evicted from public housing, and this was upheld by the Supreme Court. This policy, the one-strike eviction policy, was indeed softened during the Obama administration by two particular guidelines in 2015 and 2016, so it's not quite as severe as it was during its heyday. As far as current housing policy goes with regard to the one-strike eviction policy, I have no idea, to be quite honest with you. We haven't heard anything specifically relating to this. The focus has been more on issues of discriminatory housing policy than this one-strike eviction policy. So I have no idea what the trajectory of this particular policy is going to be. Okay, so we talked about how having a criminal record or even knowing someone with a criminal record can impact someone retaining their housing. Having a criminal record can also impact someone getting housing. And generally speaking, public housing authorities, people that own federally assisted public housing, private landlords, have extremely broad discretion to set their own screening. And I kind of like did a pick of some very interesting challenges with this, and I pulled up a couple of things. I pulled up one state has just a flat ban on individuals and their family members. If anybody has a criminal record at the time that they're applying, they are not allowed to obtain housing. Another state had a 99-year look-back policy. So if Grandpa has something on his record from 1934, that policy would ban him from obtaining housing and you if he were going to be living with you. It's also important to remember that there's no appeal process for refusal of tenancy. They just turn you down and that's the way it goes. So housing is a significant challenge, both retaining and obtaining housing when you have a criminal record. It is also incredibly different to get a job and to get licensed to perform a particular occupation if you have a criminal record. Some general statistics from the EEOC, between 80 and 92% of employers run background checks. Having a criminal record significantly reduces job callbacks and significantly limits earning potential, hours that are given to the individual, and this is not something that only a few people are dealing with. This is 70 million U.S. adults, so that's 1 in 3 U.S. adults are dealing with barriers related to securing employment. If we switch to occupational licensing, so if there are social workers on the phone, we had to be licensed to be able to practice our profession, and that's really common in a ton of different occupations. The National Inventory of Collateral Consequences of Conviction estimated when they did a sweep that there were 16,772 licensing or occupational laws that were related to somebody having a criminal record provision, and 6,000 of those were mandatory or automatic exclusions as opposed to those discretionary exclusions that we chatted about. The two most heavily licensed occupations were healthcare and education, which has, again, if we are thinking intersectionally about this, has a disproportionate impact on women, who are the individuals who go for healthcare and education-based jobs the most. However, it is in this area that we have had the most advancement. We've had the most success in legislation that has decreased some of this burden. So in 1987, the EEOC declared that having blanket bans on hiring people with criminal records was a violation of people's civil rights. So you can't just say anyone with a criminal record can't have this job. Okay? The real advancements began in 2010 when states began passing what's called a ban the box measure. And essentially what that is on the front page of an initial application for a job, there is typically a box which you have to check if you have had contact with the criminal legal system. And states began passing these measures to say we're going to take that box off of this initial application to allow somebody to get their foot in the door. It's not banning background checks. It's not banning these discretionary collateral consequences. And it's not that employers can't use someone's criminal record to make as a part of making their decision. But these ban the box measures were simply designed so that people could get that second interview, could get that face-to-face time with an employer and sell their qualifications and their skills and maybe explain, I had a conviction 20 years ago and this is what I've done since. Just giving people the opportunity further than I look at your application, I see that the box is being checked and I throw it in the garbage. In 2012, the guidance was expanded and stating that exclusions may have disparate racial impact. So again, acknowledging that this is not a one-size-fits-all issue. This is something that impacts people of color more than it does white individuals attempting reentry. And the EEOC recommended that there be job-related and individualized assessments recommended instead of these kind of blanket blanket check boxes for whether or not somebody has a criminal record. And as of this year, 30 states have adopted statewide ban the box laws or policies. So we're really moving in the right direction here as far as employment and occupational licensing are concerned. Public benefits are another area where criminal records have a big impact, but again, where we've had some success. In 1996, President Clinton signed the Personal Responsibility and Work Opportunity Reconciliation Act. I don't know if it's just me, but I read an awful lot of judgment into that particular title. And what this particular act did was put a lifetime ban on receiving public benefits through temporary assistance to needy families and SNAP, which is food stamps, for drug-related felonies. So in the mid-90s, when the war on drugs changed policing, it changed incarceration rates. We also said that if you were incarcerated for a drug-related felony, if you were convicted of a drug-related felony, now you can't even get food stamps or assistance for your family. And there was, I think we're at least starting to cross to the other side of understanding that these type of measures don't do a single thing to keep people off drugs. If anything, it makes them more vulnerable to continuing to use or to deal drugs because you can't make ends meet. That being said, states were also given the option of waiving or modifying the ban. And again, advancements in this area have gotten us to the point in 2017 where all but 6 states have modified or eliminated the ban, 20 of which have eliminated the ban completely. Maryland just passed something in the last legislative session to kind of hack this thing to bits even more than it already was. It's important to understand, though, that anyone with ongoing criminal issues, so bench warrants, probation or parole violations, can still remain ineligible for food stamps and assistance and SSI. So kind of the continued interaction with the criminal legal system, even if your state has reduced or eliminated these bans, you may still, or your client may still have these challenges with basic needs, or meeting basic needs, I should say. Again, if we put our intersectionality hat on, this does not affect everybody the same. Challenges with obtaining public benefits impacts women primarily because 85.7% of these recipients are women. And obviously that is because women tend to care for more children than anyone else. Children tend to suffer as well with these type of bans, even though their access to TANF, or again, temporary aid for needy families, is not reduced themselves. The overall TANF benefit for the entire family is reduced by that ineligible adult family member. So if it is me and a small child and I am banned from getting TANF, my child can still get it, but we are both now going to have to live off of that. And so having the caregiver be banned or limited from receiving TANF harms children as well. And I think I've kind of beat the horse on this a little enough, but there's also a direct correlation with enforcement of the war on drugs in communities of color. So if we are policing for drug offenses far more significantly in communities of color, we're going to have higher levels of convictions in those communities, drug-related convictions, and we're going to have higher numbers of people who are limited or banned from receiving public benefits. Individuals can also be impacted, access to federal student loans can also be impacted by having a criminal record. The way it works now is that if you are already receiving federal student aid, your aid may be suspended if you are convicted of any drug offense, whether it's at the state or the federal level, whether it's a misdemeanor or a felony, whether it is for possession of drugs or distribution. So we're talking about drug trafficking down to simple possession. If someone has federal aid, it can be suspended if they are convicted. The Department of Education, with regard to applying for education, has applied this type of drug-related ban much more broadly. But as far as federal aid, it's only going to be suspended if you are convicted of a drug offense while you're receiving that aid. And you'll see that I highlighted there are challenges with, or bans that have to do with possession and bans that have to do with sale. And those differ a bit. Okay, so we talked a little bit before about the intersection between child care and individuals who are justice involved. And so what I've got for you is some numbers. So in 2007, approximately 1.7 million children had a parent who was in prison. And that, again, is a phenomenal increase, an 80% increase between 91 and 2007, and disproportionately affecting mothers. So there is a 122% increase in incarcerated moms between 91 and 2007, and a 76% increase in incarcerated fathers from 91 to 2007. And currently, nearly half of all U.S. children have at least one parent with a criminal record. Because remember, we're talking big picture who's incarcerated, but then we're talking the people who leave incarceration and are attempting to move on with their lives. So the numbers are staggering, and the money is a challenge as well. So for instance, prior to an Obama-era regulation in 2007, incarceration was actually considered by child support services in 14 different states to be voluntary unemployment. And so these individuals, when incarcerated, could not actually pause their child support payment. And what was happening is people were leaving jail with tremendous amounts of child support back payments due, perhaps not eligible for food stamps, having trouble getting a job. And all of this affects young folks because it damages familial relationships, it damages reunification, and for someone with an outstanding balance of child support money, they can be impacted in their ability to get a driver's license, and they can also be jailed for not being able to actually make these payments. Luckily, there was a regulation in 2007 that the Trump administration has allowed to go into effect, which bans this kind of voluntary unemployment concept and requires states to create realistic payment amounts relating to the individual's earning potential, which obviously in jail is small. I'm sorry, I just have to reply to one of the questions and comments, voluntary employment, who came up with that? Orwell. I don't know who came up with that, but I think that that's a pretty good guess. All right, so we've talked about the numbers, we've talked about the fact that the money of child support is impacted, and now let's talk about the impact. And there is said to be a 2-generation barrier to financial stability, education, housing, and family strength. I found a great quote that I thought was really meaningful in terms of the impact on young people, which states that parental incarceration is one of the most severe forms of trauma a child can go through, with major social, emotional, and academic consequences. So we were, when we were talking about the scope of mass incarceration and the scope of people with criminal records, we are primarily referring to adults, but we have to remember that this falls squarely on the children of these individuals as well. And having this 2-generation barrier to stability significantly exacerbates child poverty. So it has a direct correlation to the number of kids who are living in poverty. I mentioned before that accumulation of child support arrears damages reunification, and it's also worth noting that when you're talking about the best interest standard for purposes of child custody, determining child custody and visitation, criminal records factor into this best interest standard. So having a criminal record interferes significantly in the lives of the children of the people with criminal records. Okay. So having a criminal record also has a significant impact in terms of immigration. I am not an immigration attorney. I had these slides checked out by an immigration attorney, so I'm just going to present the information as straightforward as I can. In addition to jail time, immigrants who are convicted of crimes in the U.S. or even arrested can face immigration detention, travel limitations, and removal proceedings. It's important to note that conviction is not defined in the same way for purposes of immigration as it is in the slide that Kate talked about, being found guilty of a crime. So for purposes of immigration, conviction is defined as a formal judgment of guilt, a plea of guilty or nolo contendere, or if the alien has admitted sufficient facts to warrant a finding of guilt and there was some form of punishment imposed. So what that can include is a deferred adjudication. So here in Maryland, there is something called a PBJ, or a probation before judgment. And essentially the judge enters a plea of guilty, and then there is some sort of punishment imposed. So the person has to stay out of trouble for 6 months, or they have to complete a year's worth of probation. That would be considered a conviction for purposes of immigration. The good thing is, and you're kind of building towards learning about vacature and vacating convictions, is that convictions that have been vacated don't count for purposes of immigration, where the basis for granting vacature was a procedural or substantive defect in the proceeding, and that has a lot to do with how the orders are written. But you're going to get a ton on that in the vacature and immigration webinar that's coming up. There's two other things that I want to point out with regard to immigration. First is a term called crimes involving moral turpitude, and I like to highlight this because if you're working with people in the sex trade, they are more than likely going to have a prostitution conviction or a prostitution arrest, which is considered a crime of moral turpitude. So I wanted to kind of highlight this piece just for that purpose. So for one crime of moral turpitude that carries a potential sentence of 1+ years, immigrants are considered deportable if that offense is committed within 5 years after the date of admission. So with prostitution charges in the state of Maryland, the incarceration sentence or the potential sentence is a year, 1+ year. So any immigrant who has been admitted to the country that has one crime of moral turpitude offense on their record within 5 years would be considered deportable. Another change that has impacted immigrants and their interaction with the criminal legal system is the term aggravated felony. And so I gave you a little timeline. So in 1998, this is the first time we hear this term aggravated felony, and probably makes sense that it only includes murder, kidnapping, rape, drug trafficking, and weapons trafficking, right? But what happened is as the legislation built on this particular term, the term aggravated felony became bigger and broader. So in 1990, the crimes of violence with a 5+ year sentence was added to that list of murder, kidnapping, rape, drug trafficking. But in 1996, the sentence length was shortened from 5+ years to 365 days or more. So that's 5 years to 1 year, right? And so now what the outcome of this is that offenses that are neither felonies nor aggravated can now be classified as aggravated felonies. So these changes have severely changed, or these legislative advancements, or if you want to call it that, have severely changed the definition of aggravated felonies and have put a lot of foreign nationals squarely in the line of fire as far as immigration is concerned. The last piece of less collateral consequence that we're going to talk about is voting. And this is another area where we've had some significant progress. Back in the 80s and 90s, it was really common for states to enact significant or pretty severe, harsh restrictions on voting for people who were incarcerated, but also people who were out of jail and simply had a criminal record. Just to kind of come down on something a little bit more positive, this is the most recent map from the Brennan Center for Justice, which highlights criminal disenfranchisement laws across the United States. And you'll see that now there are only 3 states where there is permanent people who have felony convictions are permanently blocked from voting unless there is something like the pardon, so someone's individual rights are restored. So the only states that have that at this point are Iowa, Florida, and Kentucky. And even the next step down, which is permanent voting blocks for at least some people with criminal convictions, is only in a few different states. And we go down to, like Maine and Vermont, where there is no disenfranchisement for people with criminal convictions. So this is another area where we've had some good progress and continue to have progress. So why is all of this important? We're talking about the scope of mass incarceration. We're talking about the reach of criminal convictions. And what we really want to highlight is that this is a cycle that is incredibly hard for people to get out of. So it doesn't really matter kind of where you enter this cycle in. So we start in poverty. If we start with someone living in poverty, this is someone that is going to more likely have contact with the underground economy and is going to be more vulnerable to being arrested and being thrust into the criminal legal system. And just the cycle keeps going around and around in terms of recidivism back in jail, the stigma that comes with that, and it really becomes a whirlwind that people can't necessarily pull themselves out of. So what we want to focus your attention on now is, why is the criminal legal system this way, or at least try to explain that, and then talk about or kind of point your attention towards some types of legal relief that can help pull people out of this cycle.
If we had an opportunity to do another poll, I would ask, how many of you have spent any time in criminal court? But since we didn't plan that much ahead, I will assume that some of you may have spent some time in criminal court, either professionally, personally, that you may have walked through the doors. And I imagine the first thing that sort of strikes you on a very, very visceral level is just the level of dysfunction and disrespect for humanity, civil rights, due process that sort of permeates every step of the proceeding. I say this to just sort of put it to you as quickly and bluntly as possible, which is the criminal court system is dysfunctional. Nobody who has worked in this system, even anyone who's worked in the system with the best intentions, would disagree with that statement. And this is for a lot of reasons, but mostly just because of the high volume and limited resources and how those match up. So when you have the number of people entering our criminal legal system as we do currently, and not enough resources and not enough creative solutions and not enough real frank discussion about why we are arresting people and what we're arresting people for, what happens is we have a countrywide indigent defense crisis. What does that mean? There are not enough lawyers assigned to represent people who cannot afford to hire counsel. Those lawyers don't have enough resources. Those lawyers struggle under the constraints of incredibly high caseloads. The pace at which cases need to be resolved in criminal court, and I spoke about this a little bit earlier on in the webinar, does not lend itself to actual careful consideration of each case. There's simply a high volume of cases, and this impacts all of the stakeholders. And so what happens is confusion. Confusion and often outcomes that are not just and don't measure up with what most people would hope for and expect from our criminal legal system. This all has specific impact on human trafficking survivors. And the Survivor Reentry Project and the work that Jess does in her legal clinic and the work that I do in my legal clinic, and I know the work that many of you watching or participating in this webinar also do, focuses on people who have been trafficked into commercial sex or other forms of labor. Jess just gave an amazing general overview of all of the collateral consequences that criminalization can have on an individual, a family, or a community. But what does this mean specifically for survivors of human trafficking? We know, for example, that human trafficking victims belong to marginalized groups in many ways. We understand that human trafficking impacts immigrants, women, people with disabilities, trans or gender nonconforming individuals. And so as a result, we know that human trafficking victims just already, for the reasons that Jess outlined, are at high risk for arrest. But then we also understand that different policing strategies, right, increase the likelihood that victims of trafficking will come in contact with the police. One of those policing strategies right now is actually the effort to combat human trafficking. Increased policing of the commercial sex industry, increased attempts to investigate and prosecute human trafficking tend to cast wide nets and ensnare in the criminal legal system many victims. For sex trafficking victims, we understand that they can be arrested frequently for prostitution or prostitution-related charges, but also for many other types of charges like weapons, drugs, theft. Labor trafficking victims, like sex trafficking victims, also can be swept into the criminal legal system, as labor traffickers can benefit from forcing a victim to commit illegal acts such as selling or cultivating drugs, using false documents, right? Even other minor offenses such as trespassing can bring people into the criminal legal system. Why doesn't our criminal legal system identify victims at the time of arrest and prosecution? I believe, although on a bad day I might actually deny this, that most people, most stakeholders in this process, whether it's police officers, prosecutors, judges, don't set out to arrest victims of trafficking and bring them into the criminal legal system. But yet this happens. And why does it happen? Why are they not identified as victims at the time of their arrest and prosecution? Well, as I've already explained, the systems are overwhelmed and individual circumstances are not really considered. Victims often don't disclose during the arrest process. So even where certain screening systems or diversion courts or other initiatives have been implemented, many different factors can still prevent people from disclosing their victimization. And a lot of this makes perfect sense. It makes perfect sense if you consider where people are when they are experiencing victimization and what the process of an arrest and prosecution might do to them. But people also may have had negative experiences with law enforcement and the criminal legal system in the past. And this might inform their view of the process and their willingness to trust actors in the process as well. So human trafficking survivors basically face all of the same consequences that we've already detailed. We understand the employment, the housing, education, immigration relief, all of this. But like anyone whose own victimization is tied to their criminalization, there's some added layers here. And for human trafficking victims who have been arrested and prosecuted and come into the criminal legal system, there are, in addition to the specific barriers that everyone faces, there are some real ways in which their criminal histories, their criminal records, serve as a constant reminder of their experience and can sometimes bring up shame, reliving trauma, stigma. When survivors of trafficking have to disclose, for example, to a potential employer or a housing official, not only their criminal history record, but any then context related to that record, they have to essentially disclose their victimization in a not particularly friendly or supportive environment. And oftentimes this leads to survivors having to then choose. Do I want to share this information and go through this, or should I simply walk away from this opportunity? It's worth noting that the National Survivor Network, which is a national network of survivors of human trafficking, did a study in 2016, and the respondents were all survivors of human trafficking. 90% of respondents had been arrested because of their experience being trafficked. And as a result, 80% had faced barriers with employment and 50% had faced barriers with housing. And criminal records can also be used by traffickers specifically and be used in ways against a survivor of trafficking. For example, in instances where a trafficking survivor has children in common with her trafficker or his or her trafficker. And a trafficker can go into family court and point to a criminal record as evidence that someone is unfit to be a parent, or use it otherwise in custody or family law matters. So there are very specific ways in which the overlap between someone's trafficking experience and the likelihood or the fact that they've been arrested and brought into the criminal legal system continue to present harms and obstacles for survivors of trafficking, even after they have gotten out of a trafficking situation. So what do we do about this? Well, we try our best to think of ways to work with survivors to clear their criminal records. And this is what we mean when we say post-conviction relief. Anything that happens after someone has been arrested and brought into the criminal legal system that will help relieve some of the burdens on them that came by virtue of that arrest or involvement. I'm not going to go into too much detail on how you can clear a criminal record, mostly because I can't tell you this now because then you won't watch the webinars in the future that we have planned. And also there's a lot of nuts and bolts here that we would want to get into in walking you through how to clear a criminal record and how to do that specifically with survivors of human trafficking. But there are some ways after conviction or after someone's involvement is over that you can clear a criminal record. There is a phrase that we utilize now called vacatur. And this is mostly to sound smart and fancy, but what it actually means is vacating or undoing a judgment of conviction. A judgment of conviction, if you think back to our earlier discussion, is a finding of guilt in a criminal proceeding. It's actually a judgment that's entered against someone. If you vacate that judgment, you're going back in front of the initial court to undo it completely, as if it never happened. And Jess began to touch on this when she was talking about the immigration context and how vacatur is interpreted. But really what we're saying here is there was a problem. Something in the initial prosecution was incorrect. The initial adjudication was incorrect. In some places, even if you successfully vacate or undo a conviction, the record of the arrest or the prosecution itself might still be visible. In some places, there's an additional step then to clear that portion from public view as well, or to seal that portion. And as we will discuss in an upcoming webinar, even when convictions are vacated, there may still be a question as to how they're interpreted by immigration officials. Expungement refers to the removal of records from public inspection, although I have to give a little bit of a disclaimer here and explain that this is going to sound horrifically lawyerly, but we have to proceed with caution because some states utilize expungement that it lines up more with how I just described vacatur. These are sort of terms of art that are used interchangeably across states and through different criminal procedure laws, and so the best thing to do if you have questions about this that are specific to your jurisdiction is to call me later. because we can go through it. What we talk about expungement in one state or vacatur in New York, for example, it's often we are doing so in comparison to general expungement or sealing provisions that are available to, across the board. And so when we think specifically about what might be available to human trafficking survivors, there's a lot of nuance and complexity. So my answer now is this is really, really broad strokes just to give an idea, and we can get into much more depth on the case level or at the policy level for your specific jurisdiction. Expungement can apply to both convictions and non-convictions, meaning those arrest records or prosecution records that didn't result in a finding of guilt. After an expungement, someone can typically answer no to questions related to arrest or conviction in, for example, the employment context. But this, again, for immigration, everything. The answer is everything may have immigration consequences. And so even if something is expunged, USCIS will know about it, and there will be a question as to how it is interpreted. Finally, there are sealing or shielding provisions that exist in many states. And this really refers to the hiding of records from public view. These records still exist. There's not been a finding that there was anything wrong with the initial prosecution case, disposition, or outcome. Simply, the cases are not visible by members of the public or in certain searches. Typically, these records, even sealed or shielded, try saying that a million times fast, these records remain accessible to law enforcement, certainly to the criminal legal system for subsequent arrests, and certain employers, depending on the level of background checks that they do, may also see sealed or shielded records. Finally, if they're to take things outside of the judicial branch, all of those options I just went through, vacating, expunging, sealing, shielding, all exist within the court system. Individuals go back into the court system to seek relief from the court that originally adjudicated their case. On the other hand, pardons go through the executive branch. And pardons are a more formal recognition of forgiveness for a criminal conviction. They may, in certain instances, restore rights lost due to conviction. They may open up other options, but this is a separate proceeding through the executive branch that really doesn't question necessarily whether there was something wrong with the underlying criminal proceeding. This is about forgiveness, rehabilitation, and so it's a different pathway altogether. In 2010, New York became the first state to create a specific form of post-conviction relief, vacatur, for victims of human trafficking. This was a huge development, both in criminal record advocacy and in the world of anti-trafficking advocacy, because it recognized almost everything that we've been saying today. One, that collateral consequences flow from criminal system involvement. And two, that victims of human trafficking are being swept into the criminal legal system, not being identified, and then suffering the consequences. So New York's remedy was the first of its kind. It was extraordinary. And it gave legislative recognition that, particularly for victims of human trafficking, this was an issue, and this was an issue that we needed to create a remedy for. Since then, as you can see, the proliferation of these laws and the types of relief across the country have exploded. And it's been amazing to watch this happen, so that every state you see highlighted on the map now, and for those of you that may be participating from states that are gray, we can talk about that another time, but all of those states, the orange, purple, and blue, offer some form of relief to victims of human trafficking after conviction, after arrest and prosecution. The blue states, Georgia and Louisiana, have laws that apply only to minors. So folks who were victims as minors and were arrested as minors. The other states, Kansas, Colorado, New Mexico, Texas, and Arkansas, that purple group clustered together, offer sealing or shielding only, right? So not the actual undoing, vacating of a conviction. And the orange states are more full relief in that they offer the vacating or expunging of convictions. Many now started at the point of allowing survivors to come back in and ask a court to vacate or clear only prostitution-related convictions. As you can imagine, that was sort of a limited view of this because, one, it only applied to people who were trafficked in the commercial sex industry. And even for that group of people trafficked within the commercial sex industry, many victims were arrested for other offenses other than prostitution as a result of their victimization. So since New York enacted its law, which only applied to prostitution offenses, but we're working on changing that right now, other states have embraced a more expansive understanding of how victims of human trafficking may come to be arrested and what relief is necessary then to remedy the collateral issues that flow from that. So states like California and Florida offer broader relief and allow victims to vacate a whole host of nonviolent offenses if they were connected to their victimization. We're working in Nebraska right now, Tennessee, Massachusetts, to bring about legislative change to see remedies available at the state level in those areas as well. So all of this is to say that the remedies that we are starting to see are a complement to existing remedies that were very limited in many cases. Many states, although not all, offered some way of expunging or sealing records. Usually this is after a certain amount of time has passed, and provided that someone has not been arrested again and can prove that they have either been rehabilitated or that they have the good character now that justifies expunging or sealing records. Where we want to go with this effort, particularly with human trafficking survivors, but obviously in thinking about the scope of criminalization that we've gone through today, we need to be thoughtful about making sure this applies to as many people as possible. But for human trafficking survivors, we want to make sure that we're moving in a direction of really placing people in a position as if their arrest and prosecution never happened, so that all of the consequences that we've outlined are not barriers to them moving forward. We need these remedies to be as complete as possible and to reflect really all of the specific detail and procedure at the state and local level, down to the question of who handles the fingerprinting and where is it communicated, and really account for all of that so that criminal records do not continue to hold survivors back. I want to make sure to encourage all of you to ask any questions at this point as we're nearing the end of the webinar. So if you'd like to ask any questions that you want us to answer in our remaining minutes, please feel free to do so. But I also would like to take the opportunity to encourage you to, if you are interested in learning more about the framework of human trafficking, specifically for attorneys, and a broader overview. We've just begun to touch here on human trafficking victims and arrest, but for a general overview and a wealth of information, CAST, the Coalition to Abolish Slavery and Trafficking, based in Los Angeles, has developed an e-learning series. You can register at their website, and we highly recommend for attorneys, particularly those wishing to get involved in more human trafficking work and learning some of the basics, the overview, to register for and attend the Human Trafficking Defined class for attorneys. We also have a few upcoming webinars through the Survivor Reentry Project, and this will give me an opportunity to also describe briefly what the Survivor Reentry Project does. The Survivor Reentry Project, which is run through the American Bar Association's Commission on Domestic and Sexual Violence, is a training and technical assistance project on the very specific issue of post-conviction advocacy and the criminalization of human trafficking victims. We also serve as a clearinghouse, not only for inquiries from professionals, advocates, non-lawyer advocates, medical professionals, but we serve as a clearinghouse for survivors themselves. So as I mentioned earlier, many people do not know exactly what appears on their criminal record or what would appear to an employer were they to be fingerprinted. What we do is we encourage human trafficking survivors to get in touch with us directly. We have a confidential link through our website that connects people to us. They can submit a request. We walk people through fingerprinting, ascertaining criminal history. Then we analyze with folks what might they be eligible to clear from their records. And what we're working to do is develop a network across the country of not only lawyers, but advocates and other practitioners invested in making this happen. and invested in reducing some of those consequences that we've been through today. So survivors can get in touch with us completely, as can any practitioner or advocate, to ask questions about this. And what we're trying to do is, particularly for survivors who, for example, now live in one side of the country, but were arrested and prosecuted during their victimization up and down another side of the country, we are trying to make sure that their representation is streamlined, that it's good, that it's sensitive, and that it accomplishes the mission of getting post-conviction relief in the least harmful way to them. The criminal legal system, some might bicker with my characterization earlier, but it is ultimately a system that can be harmful. It can be harmful for people prosecuted. It can be harmful for victims of crime. It can be harmful. All of this is harmful, all of the collateral consequences that we went through today. So these areas where we're seeing innovation and development of post-conviction relief, and where we're seeing the investment of communities in making this a priority, is an opportunity to really make significant impact both at the individual level and at the community level. This stuff influences the criminal legal system and makes it a little less harmful. We are going to be wrapping up now. Jess, I'm going to give you one more opportunity to share anything that I missed.
I do not think you missed anything, but what I do want to highlight, I want to highlight and draw attention to something that Kate said, which is that these challenges, the challenges with housing and public benefits and all of those things, they happen to everybody with a criminal record. Kate obviously helped you kind of transition into thinking about everyone with a criminal record to human trafficking survivors with a criminal record, but I want to make sure that people know that this is a struggle that people are having all over the country. And when folks have criminal records, they are more vulnerable to being trafficked. So when you focus on criminal legal reform, you are doing human trafficking prevention work. When you focus on doing anti-poverty work, you are doing human trafficking prevention work. And really just never forgetting, I said it at the beginning, there is no one issue, right? All of the work we do with survivors intersects with race, with gender identity, with poverty, with policing, and really making sure that we don't get stuck in our silos, and that we look at communities and families whose lives are improved by criminal justice reform and things like that, as doing our work and preventing us from having more clients, is the best way that I can put it. But I know we're wrapping up, and I just wanted to say thank you all so much for listening to us on your Tuesday afternoon.
On behalf of the American Bar Association, Commission on Domestic and Sexual Violence, thank you for participating in the program.